Classified Crime is on the case of Sarah Boone, and today we're going to take a look at two conflicting, contrary, and hypocritical motions, both filed by Sarah. We have Sarah's filed amended answer and waiver and dismissal of counterpetition filed on 5/9/2018. And it reads, the wife, Sarah K. Boone, hereby files this amended answer, waiver, and dismissal of counterpetition as follows. 1, the wife neither admits nor denies the allegations contained in the husband's petition, but does not desire to present any defenses. So this Sarah from 2018 was like, I don't admit or deny what he's saying, but I don't want to defend myself. Like, I don't want to exercise my rights that are in the Florida and U.S. Constitution. Okay. So this is a whole different ballgame. 2, the wife admits the marriage between the parties is irretrievably broken. 3, the wife requests that this court incorporate the provisions of the marital settlement agreement and parenting plan dated the 3rd of May, 2018 into its final judgment. 4, the wife hereby dismisses her counter petition filed in this cause. So she totally withdrew that. 5, the wife waives her right to personally appear at the final hearing, provided that the final judgment is entered consistent with the marital settlement agreement and parenting plan. And she signed and dated this May 3rd, 2018. So isn't that interesting? Now, scooting on over to August 20th, 2025 at 12:02 p.m., this was filed in office of the clerk of court of Orange County. So that means someone hand delivered this for filing. Okay. So in the circuit court of the 9th Judicial Circuit and in Fort Orange County, we have the case number, Brian Boone petitioner, Sarah Boone respondent. This is the respondent's motion to appear in person for trial. Comes now, pro se respondent, Sarah K. Boone, and respectfully moves this honorable court to issue an order for her transport to rightfully and properly represent herself by being included in person for the final hearing in her family law trial on August 25th, 2025, in support of the respondent's request for equal full inclusion. So here's her list of things she thinks supports this motion. So buckle up. 1, respondent has been ordered by the court without hearing July 28th, 2025 to appear and participate telephonically in this trial due to her incarceration. 2, by quote unquote appearing via telephone for this vital life-changing trial, the respondent's rights and position are heavily impaired, increasing an unfavorable outcome in her self-representation by being excluded in the courtroom with all other parties, in which she is and should be included as such. What? So this is an opinion, and I'm not a lawyer, but in a courtroom, they're not interested in opinions unless they are from a certified expert that has been requested to give their professional opinion. Sarah's not a professional at anything but drinking, so we don't need your opinion about why you think it will be impaired, unfavorable outcome. Those are just your opinions. These are not facts. These are opinions. There's no case law. There's nothing to support. This does not support your request. 3, in-person representation is crucial for the respondent to ensure meaningful access to the court by having the ability to present evidence for her defense, cross-examine witnesses, respond appropriately to arguments made by the petitioner, and accurately perceive the dynamic of the courtroom as a whole. So why do you need to perceive the dynamic of the courtroom? You don't understand the dynamic of a courtroom. You've spent quite a bit of time in courtrooms this past year. What witnesses are there going to be besides you and Brian? Like you don't know how to cross-examine him at this point. Meaningful access to the court. So what is meaningful access? So over the phone isn't meaningful. I mean, lots of people appear via Zoom or telephone in court hearings all the time. It happens all the time. That doesn't mean it's not a meaningful appearance. You just don't want to sit in jail the whole day. You want to go on a road trip on the taxpayer dime. 4, as a self-represented, parentheses, pro se, litigant, the respondent is at a significant disadvantage when, quote unquote, appearing by phone. The quotations for me, every time she doesn't agree with a word being described as something, she puts it in quotations as if it isn't actually that. You are appearing. You are able to appear, to participate, to speak. You don't need to drive 3 hours to Orlando from Ocala to ramble on and on about this nonsense. Okay, let me go back. As self-represented pro se litigant, the respondent is at a significant disadvantage when appearing by phone, especially in a complex trial setting where immediate review and understanding of documents, real-time responses to developments as they arise, communication with the court, presentation of exhibits, observing the opposing party's demeanor is necessary. It is essential for her to engage in all court proceedings for this trial. Observing someone's demeanor has nothing to do with presenting facts. Someone's facial expression has nothing to do with the facts. You were supposed to have filed all your exhibits. You probably haven't accessed the court docket to look at any exhibits. So you want to be there so they can hand you the copies. You can look at them and you can drag it out for hours and hours because you're unprepared. But that's not anyone's fault. It's no one's fault that you're not prepared. 5, remote participation impedes the respondent's ability to fully advocate for her position and interest, particularly given her documented difficulties in accessing legal materials, submitting and receiving documents from the court and opposing counsel, and communicating effectively from within the correctional facility. And why are you in the correctional facility? Who put you there? Why are you there? Your actions put you there. Your behavior has caused you to be restricted from full access to society and all of the benefits thereof. So that is why you cannot access legal materials, submit and receive documents. I mean, even though that you could theoretically do that, but you still haven't figured it out all this time, how to access your own stuff. I'm sure there's other people with the same predicament in there that are accessing their court cases. I don't know how many physical copies have been demanded from how many parties from you. I'm sorry, I'm ranting. I'm really tired because I worked overnight. All right, let me move on. The 6, the respondent's physical presence and participation greatly minimizes the risk of technical difficulties, which can delay, interrupt, or obscure communication and allow the respondent to interact directly, clearly, timely, preserving the court's invaluable time. She's correct that there could be minimal technical difficulties when we're not using Zoom or some kind of technology to broadcast her into the courtroom. However, they would certainly overcome those difficulties if they should arise. This is a crystal ball moment. And then wait until they're resolved to proceed. And also, there could be technical difficulties with transporting you there. What if there's traffic or a car accident and you're late? The respondent 7, the respondent's transport to the court and proper inclusion in the courtroom serves the legal interest of due process. Why? Where's the case law supporting that? Why does it serve the legal interest of due process? Also, due process for a civil case? I'm not a lawyer, but does that really apply here? I don't know. Due process, increasing her ability to be rightfully understood as a serious and committed party in this case in respect for the court, ensuring fairness and justice under her extraordinary circumstances. The Florida and United States constitutions. This is a civil case. So rightfully understood, taken seriously, ensuring fairness according to, is there any kind of legal argument here? Wherefore, pro se respondent Sarah K. Boone respectfully requests from this honorable court to enter an order for transport to fully have the ability to represent herself in this family law trial, and after her continued determination, eagerness, hard-fought effort to do so for a hopeful legal and just outcome for over 5 years. This is a rambling rant, and this was respectfully submitted the 8th day of August 2025, so I don't know why she had such difficulty getting it filed up until the 20th. But as you can see, and then she says she sent it to Brian's attorney via mail, expedited. So I wonder who paid for that. But it says up here at the top, filed in office. So if you were really concerned, you would have met your deadlines. You would have filed the appropriate requested documents that you were asked to file before the trial. You would have submitted everything. You would have not been focused on whether you're there in person or on the phone. You would have been focused on getting your stuff submitted in a timely manner. And now it's the very last minute. And of course, I'm sure there's a reason why that's not her fault, but she wants them to throw a Hail Mary and get all this stuff arranged. You know, there has to be staffing for that. There has to be officers available to transport you there and back and be taken off of whatever other duties they would normally have for an entire day, so you can look at people face to face and twitch your mouth at them. I mean, if I feel personally, my opinion, not professional in any way, my opinion is that the judge is going to say denied to this motion based on no legal argument or no support, no legally supported argument. Because it's just her thoughts. These are how she feels. Sarah thinks that how she feels matters to a court, and it doesn't. The court cares about how, in family court, they care about how the child feels, not the parents. And then, secondly, they'll look at the parents, how the parents are, who's under more strain in dealing with raising the child and their ability to focus on that, rather than having to deal with frivolous things that can stress them out and cause them to take their focus off of raising the child, because raising the child is the primary focus. You can't raise a child. You're incarcerated. You can't take them to appointments. You can't call and schedule appointments. You can't have a parent-teacher conference. You can't check the grade portal to see if there's missing assignments. You can't do anything besides, how's your day? Let me call you again in a minute because I don't have anything to do. So the court doesn't care how you feel about being incarcerated. They don't care how you feel about not having access to everything you want to have access to while being incarcerated. They don't care that you feel it's necessary to spend state of Florida taxpayer dollars to drive you 3 hours and back, plus paying for someone to staff and monitor you. They don't care about that. They care about the well-being of the child. And all of these motions have made it extremely and abundantly clear that that is not what you care primarily about. And I'm just going to leave that there. All right, reading this. And then the hypocrisy with when you were walking around in the free world and living within a half hour's drive of the courthouse, within the county of the courthouse, you filed a motion to waive your appearance because you couldn't be bothered to go. It was too much for you in 2018. But now that you're incarcerated and it's an extreme amount of coordination and effort for everyone else, you should be transported. But you couldn't be bothered to transport yourself when all you had to do was make arrangements for whatever was planned or scheduled that day, postpone it, walk out to your car, go to the courthouse and show up and leave. But now everyone has to rally and coordinate and make all this extraordinary effort besides walking you into the teleconference room at the prison. No. I'm 90% sure this is going to get denied. And today's Friday. So Monday is the hearing. And I'm guessing the judge is going to make the orders, since these were just filed on the 20th on Wednesday. I guess the judge is going to order on them on Monday, because I haven't seen anything yet today. I'll check again this afternoon and post in the community post tabs if I do see anything. This weekend, I'm going to try to continue the recaps of the family trial, just so we can have kind of like a fresh in our mind what's been going on, especially the letters. And then Monday, I will be checking for updates along with everyone else. I did see Just Hear Me Out is going to the trial, and he's going to post some updates. And he was talking about maybe going to the bar she used to spend time at. So check out his channel for updates on the actual case on Monday, because that is what I'm planning to do as well. And then if anything is posted in the docket, of course, I will update you. Thank you for being patient with my rant. This particular order just really aggravated me because it's just like when it's up to her to make the effort, it's woe is me, I can't be bothered. But when anyone else is required to make the effort, it's, well, you're not doing enough and you're not treating me fairly and I'm not getting due process. And it just like, it's exhausting. And imagine the people actually dealing with her in person having to control their facial expressions, their loud sighing that they obviously want to do. I mean, think about Judge Cranick, how many times he probably wanted to like lean over, put his hand to his forehead, rub out his migraine on the side of his temples, take a sip of his coffee, and just not go off on her. And he showed so much restraint. And I know this judge will too. It has to be very hard to be a judge and show restraint every day when you deal with things like this. But we will see what happens. And I want to thank you all so much for watching. Like and subscribe. Share this video if you know someone who would like it, so we can continue to grow. And I will continue to update throughout the weekend.